The Bestiary of Debt Collector Dirty Tricks. Brought to you by YourLegalLegUp.com, your advantage if you're being sued by debt collectors. Debt collection is a hard business. They're trying to force people who are already making tough choices to make different choices. To make a person give up food or insurance to pay a bill for something that's already come and gone is hard to do, even if it's a legitimate bill. On the other hand, most people do want to pay their bills, and they feel guilty and embarrassed when they don't. The debt collectors know and use those facts regularly. You might consider them dirty tricks, but we won't discuss things like that other than certain extreme ways debt collectors play their cards, because they've got a job to do too, you know. People who owe money also usually feel and are vulnerable to various bad things, and many of the dirtiest tricks use this fact against them too. They take advantage of fear. Finally, one of the things that gets people into trouble, in debt trouble in the first place, is hope or optimism. They overestimate what they can do, or they look for an easy way out. This is one of the best tools the debt collectors have. In this video, we're going to discuss several tricks the debt collectors play so that you can recognize and prepare for them. If you'll look below, you'll find a link to the complete report that has many more tricks and a lot more about what to do about them. I have found that a lot of people come to us after doing some things that hurt their rights a little bit. I want to help protect some of those rights that might get lost otherwise. There are a few things I will say before getting into the scams and the tricks themselves. First, the Fair Debt Collection Practices Act, the FDCPA, makes almost all of the tricks I discuss here illegal, for debt collectors at least. But some of them are not, as I will discuss. The FDCPA generally requires fair dealing and honesty and makes deception and misleading behaviors illegal, as well as requiring certain things. But it only applies to debt collectors as that term is defined, and there's currently a lot of uncertainty about what exactly the term means right now. What there is really no doubt about at all is that the debt collectors, as the term is generally understood, will do almost anything to get your money. The tricks here are only a few of what they have come up with, no doubt, and even less of what they will figure out how to do. As the saying goes, where there's a will, there's a way. And the debt collectors want your money, and they will think of other, perhaps worse tricks than those that are listed here. And by here, I mean here in this video and also in the Bestiary report. And that brings me to my last point. You have to look out for yourself. No one else is really going to take care of you. Whether the FDCPA applies or not, whether the person calling you is an actual debt collector or not, all too often the law does nothing for debtors. You should never trust a debt collector to do the right thing. You must exercise all your rights and hold on to your money until and unless you are fully satisfied that it isn't a ripoff. You simply must never believe a debt collector without proof of what he or she is saying. Remember, they will always be absolutely positive and very forceful in their belief about what is supposed to happen. As you will see, most of the beasts in the bestiary involve some sort of coercion, either subtle or outright brutal. Any sort of fairness or hesitation has no part in debt collection, period, or certainly in any of these scams, unless it's actually part of the scam. Don't be sucked in by someone who is supposedly reluctant to require you to pay. That's what they're there for. They'll all try to rush you into making quick and unwise decisions. Your job is to take your time to make the correct decisions with the correct information. No debt collection is going to happen so suddenly that you don't have time to join us and attend a teleconference or two, or find a lawyer, or find help somewhere. You have time, and anybody who's trying to push you to make an action so quickly that you seem not to have time is scamming you. Remember, this is just a selection of dirty tricks. Some debt collectors will do anything at all. The tricks don't all have formal names, but I've given them names and put them in alphabetical order, which you can sort of scan in the table of contents in the linked report. And now onto the tricks. First up, asking for post-dated checks. Sometimes a debt collector will urge you to send a post-dated check. That is, a check with a date on it that's different than the actual date. You think the money will be there in a week, so you write the check for the next week. Debt collectors love to get you to do this. Why? There are some legitimate reasons, and this isn't always a scam or a dirty trick. They've persuaded you to do something, and that decision is always easily undone when it's a tough decision. So they want you to get the check in the mail before things turn you around. But the problem is you can't trust the debt collector, yourself, or the world around you with this. First off, the debt collector is probably not going to remember promising you that you could post-date a check. They probably won't remember that they're supposed to hold the check. And that supposes that they even get the check. But most likely, it's going to be intercepted by the debt collection company they work for and deposited immediately. And if that happens, you're screwed. You can't trust yourself, because one of the things that makes debtors get into trouble in the first place, as I said above, is that they're optimistic. They think things are going to be fine. They tend to overpromise. That's what the studies show. And that's actually what debt collection is all about, isn't it? And then you can't trust the world around you because things happen. And you can't foresee them in many cases. And if you've written a check and something comes up in the world, you are out of luck. Now let's talk about another trick, the attempt to collect from relatives of the dead. This is a pretty low trick. With a few exceptions, parents' or spouses' debts do not transfer to anyone else. A deceased's debts are claims against that person's estate. That means if there's a will, that any claimants will have to make a claim against the estate in probate. That is, if there's somebody owes money and they die, and they have money, to leave, then in probate, all those claims should be handled. If for some reason that doesn't happen, then in some situations, the residuary beneficiary of the will might be liable, but only to the extent of the assets from the estate, so this is not likely to come up. Now, a spouse can be liable for a deceased spouse's bills if those bills were for necessaries. But except for a very few bills, like medical bills or perhaps nursing homes, this just isn't going to come up. And it is complicated, too much for most debt collectors to want to handle. All you need to know is that if a debt collector is asking you to pay someone else's bills, it's probably a scam. Now look, if there's somebody who's claiming against someone who's against you because they were your deceased relative, then there's probably going to be a lawyer involved to handle the probate of the case. You should talk to that lawyer. Next trick, to bring a suit in a distant jurisdiction. In order for a court to have jurisdiction over a person, that is, in order for it to have the power to affect that person's legal rights, it must have personal jurisdiction. And this is kind of complicated in most kinds of law because a person has to have certain connections with the court, or the transaction itself has to have certain connections with the court. Under the FDCPA, the bill that's being sued for has got to have originated in a jurisdiction or must be that person's present jurisdiction. This doesn't seem to be much of a problem anymore because, people seem to understand that they shouldn't be sued. However, if you are sued in a court that doesn't have jurisdiction over you, its decision can be overturned either by that court itself or by a court that's more convenient to you. Unlike most motions to vacate, when brought for lack of personal jurisdiction, that is, the court never had control over you either because you weren't served or because you were too far away for it to have control over you, then that kind of motion to vacate does not have a time limit, but it does have special state court rules that you're going to need to familiarize yourself with. The next trick is to bring suit in Massachusetts small claims courts. This is a special category because of the particularly unfair judicial rules regarding small claims courts in Massachusetts. Now, there could be those same rules in other courts that I just haven't encountered yet. Okay, so I'm speaking of Massachusetts, but your first job when you are sued in small claims, or really in any court, is to find out what the rules are, what happens if you lose, and how you can transfer if it's a small claims court. And so you're going to have to research. You're going to have to research those things, and particularly your right of appeal or trial de novo if you lose, and what rules will apply to such a trial. You'll also want to know how to transfer out of small claims court wherever you may be. Now, in Massachusetts, the way it works is they have a relaxed standard of evidence in Massachusetts small claims court, so that they don't apply the rule against hearsay, which all documents that the debt collectors rely on are. They don't enforce that rule, and so the debt collectors are going to win most of those cases. Then your right to a trial de novo, you can appeal out of that and for a new trial, but the burden of proof shifts. So then, in order to defeat the unfair ruling of the first court, you have to prove that you don't owe the money, and that's almost impossible, whether you owe it or not. So that makes these things especially bad. You want to make sure that yours isn't the same, and in general, we suggest that people stay out of small claims court anyway. The rules tend to be your friend, and the more rigidly or rigorously the rules of evidence are applied in particular, the better your chances of winning. Next trick, calling the payroll of an employer or telling neighbors about, that you owe money. This is probably obvious to most people, but it's against the law for debt collectors to contact other people and tell them that you owe a debt. It isn't likely to get any money from your employer, and it would be wrong if they gave them money. Debt collectors know that, and they also know that if they got money from your employer, you could get the money back from the employer. Although, would you like your chances of continuing to work for a company you sued under those circumstances? Most likely, the debt collectors are using the calls to generate extreme pressure on the debtor to pay, because it's going to cause uncomfortable conversations about paying bills and stuff. Whether an actual creditor could telephone an employer is not so clear. Remember, it's illegal for a debt collector, but who the debt collector is not necessarily clear. The big debt buying companies have not resorted to this tactic as far as I know. Perhaps they know bad things would happen to them politically if they did. Or perhaps this is simply because they've only recently been granted creditor status by an anti-consumer Supreme Court. Next, contempt citation. In most jurisdictions, it's acceptable to fail to show up for court and to default. Of course, if you do so, there will be a judgment against you for the entire amount claimed in almost every case. And you may experience garnishment of wages or bank accounts without warning, so you don't want that, right? In some jurisdictions, a ruthless debt collector can engineer your arrest as well. Here's how that happens. Let's say that you're served a summons, or not served, and you can look at our discussion later on in the report on sewer service, and let's say you failed to show up for trial. The debt collector gets a default judgment and then looks for assets to garnish, that's wages, or assets to attach, bank accounts. If it doesn't find any or doesn't find enough, it could summon you for what's called a debtor's examination. You may or may not receive notice of a debtor's examination, in which you're going to have to ask questions if you go. In any case, if you don't show up at the examination, the court can and probably will issue a warrant for your arrest. Thus, while debtors' prisons are not allowed anymore, you will be in jail until you pay a bond, and that bond will almost miraculously certainly be the amount owed on the alleged debt. They can require these examinations as often as monthly. If you miss any one of them, they'll issue a warrant. Next trick, double banging. Double banging is one of the worst of the collection tactics, and it's blatantly illegal. I have often warned of the danger of paying debts not owed to you if you do not fight the debt collector, because remember, sometimes they will. Double banging can range from accidentally attempting to collect on a previously paid bill to intentionally collecting on a previously paid bill, repeatedly. You need to know something about the debt collection industry for this one. When an original creditor sells a debt to a debt buyer, it does so usually in large amounts, like thousands of accounts. It does not provide any paperwork or physical material in the sale. Instead, it sends a digital record consisting of a spreadsheet on all the accounts, supposedly showing when the person became indebted, how much theoretically owed at the time of charge-off, and a few other things like that. These spreadsheets are not protected from reproduction, and in fact, many shady debt collectors keep the spreadsheets of debts that they have sold to someone else. And they sell them to other people too. Thus it's possible and if it's not exactly common, at least it isn't strikingly uncommon for one debt collector to try to collect a debt that has been paid to another. That can be innocent, although it's still a violation of the FDCPA. It probably happens far more often than I know, because most debt suits result in default judgments, as you know. Be aware that the debt for which a debt collector is calling or suing you may have already been paid, or it may have been sold to somebody else. Collecting on such a debt violates the FDCPA if the company is a debt collector. Now, for the reason this trick landed in the Bestiary, there are some debt collectors who double bang on a regular, intentional basis. Why they do so should be instructive to you. They do it because they can. They have harassed some poor guy into paying a debt which may or may not have been legitimate and which may or may not have been owed to them. And what do they think they've proven by this? That some people will really sacrifice to pay the money they owe? Of course not. They've proved that they can make this guy pay. They know he didn't want to and wouldn't have if they hadn't hounded him. And so the fact that he paid is proof that he can be forced to pay. He can be shaken down. If you can do it once, why not do it again and again and again? In fact, in one known incident, the debt collector collected on the same bill 10 times. Now, hearing that story, you probably think, I would never do that, and perhaps you wouldn't. I like to think that people who see our materials are a cut above, but these guys are professionals. They know how to rig the situation to terrify the people that they're after, and I wouldn't be too confident. Now, the legitimate debt collectors are going to say, hey, these stories aren't about debt collectors. But that's what the people calling you will say they are. They'll be saying that they are calling on a debt. So I'm not concerned whether the people who are calling you are legitimate debt collectors or not. I'm concerned about the tricks that people calling themselves debt collectors will use. And that brings us to the next trick, which is false affidavits. Our next beast, it's going to seem tame by comparison to double banging, which is outright criminal in many instances, and yet it's nearly universal among debt buyers. It's probably accounted for more unjust court decisions and even more corruption of the judicial process than any other debt collector process. I'm talking about false affidavits. So what is a false affidavit? It's a sworn statement that deliberately creates the false impression that the person swearing has some knowledge about which he or she is testifying. When I first began taking debt cases, the debt collectors all filed affidavits with their cases routinely, swearing that my clients owed a certain amount of money based on their examination of the records or their personal knowledge. And they often went further, swearing to all the facts constituting a contract breach and damages, just as if the person swearing had any idea of what he or she was talking about. They didn't know anything. In Missouri, as in most states, an affidavit is required to show how a person allegedly came by the knowledge upon which the affidavit is based. In other words, the affidavit is required to show why you know what it is that you say you know. The debt collectors, they skipped that part, and the courts let them. The purpose of these affidavits was twofold, as used by the debt collectors. First, it was intimidating. It suggested the debt collector had access to, or even possession of, far more information than it actually did. They convinced thousands of people that resistance was futile. They scared them, in other words, so they didn't go to court, and instead they just defaulted on the cases. Now, I know this because I was talking to a lot of people who were telling me that. And at that point, the second purpose of the affidavits came into play. A default judgment must be accompanied by some evidence of damages, or a separate hearing is required. The affidavits were then entered into the record as that evidence, despite the fact that they were plainly inadmissible and were inadequate as affidavits. The courts based tens and perhaps hundreds of thousands of damages findings on these affidavits. The scenario plays out across the country thousands of times per day still. Not 1 in 100 affidavits I've seen from debt collectors, that is, debt buyers, not even 1 in 1,000 probably has complied with the rules of evidence. Yet every day they are used as if they were legitimate. There's more about this and about the other animals in the bestiary in the report that you can find linked in the About section below. Please check it out. You can get it without obligation. Helping people protect their rights is what we do. Protect what's yours and don't let the debt collectors rip you off. Take action to protect yourself from the debt collectors and hope others do the same. Please like this video, share it with anybody you think could use it, subscribe and comment, as all these things help others find our materials. YourLegalLegUp.com